How do you win your employment law case if it's a he said, she said matter? So this comes up quite a bit where people think that if it's a he said, she said situation, that you can't win it. And this just simply isn't true. First, let me say that you absolutely should consider the strength of all your evidence when considering bringing a case. And if you've got emails and you got the receipts, as they say, all the better. If you've got other witnesses, absolutely you should use those. And you should consider the strength of that evidence in deciding whether to bring the case and how far to push it. But don't give up if it's just your word against his word. I used to be a prosecutor, prosecute a lot of domestic violence cases, and in a lot of those situations there were only two people involved, and I won convictions in a good many of those cases with a much higher standard of proof than in civil litigation. So here's how you do it. You've got to slow down the action, and by that I mean break it down scene by scene, because you've got to paint a picture for the jury or the judge of what happened, and your testimony as the victim is as strong as any testimony out there if it's done correctly. I'll give you an example. One of the first cases I tried as a young prosecutor was one where this guy threw a water bottle at his girlfriend and hit her in the head, and she called the police and he got arrested, and lo and behold there was a trial. And it was a misdemeanor case, so it wasn't particularly serious, but that's all I had. All I had was her testimony, and then of course he was there as a defendant. And I worked with my supervisor and she told me what I'm telling you. You've got to slow down the action. If you just get up there and say, and she says, well, he threw a bottle and hit me in the head, the judge is not going to say, well, you've met your burden of proving this beyond a reasonable doubt. But if you slow down the action, you get your witness, you in this case, to slow down the action by saying, okay, before he threw the bottle, what was happening? He didn't just pick it up and chuck it at you. There were probably words back and forth. He probably had a particular stance. Maybe in this instance, he was sitting on the steps and he stood up first and he reached down and he grabbed the bottle and was yelling at her. And then you break it down even further. Well, then what did he do next? Well, he stepped toward me and he cocked his arm back. Well, show me, witness. Right? Get the witness to actually show the judge or the jury what happened. All right, he cocked his arm back and then he threw it. Well, how did the bottle sail through the air? Well, it kind of went end over end. And then where did it hit you? Well, it hit me in the top of my head. Which part of the bottle hit you in the top of the head? Well, this part. And so forth and so on. And so you paint a picture for the judge or the jury so that they can understand what happened. Because at the end of the day, it's whether they believe you or not. If you can paint what really happened, so you're not making this up. If you can paint a picture that is vivid, then people are using their common sense. They'll say, well, yeah, I could see that happening. And particularly in this case, it was a criminal case, so the defendant didn't have to take the stand. In a civil case, you can call anybody to the stand. You can call the person, the bad actor, and if he or she comes across as somebody that could have done this, well, then you can win that case every time. So don't let the fact that it's a he said, she said matter stop you from bringing your case, because you can win those cases. I hope you found this helpful. If you have any other questions, post them below, and I'll be happy to try to answer them.